Good morning. I, C.S. Swarnim Gupta, Treasurer, Indore branch of CIRC of ICI. On behalf of the Professional Skills Enrichment Committee, ICI, welcome all the participants in today's webcast. That is on the topic Conflict Resolution Mechanism Skills for Chartered Accountants. I also welcome to today's resource person, Ms. Girija Krishan Verma, and the event enablers from the Indore branch of CIRC of ICA and others present over here. So I'll just give a brief introduction about the speaker and I'll hand it over to Girija ma'am. So Girija ma'am is a certified mediator, arbitrator, and accomplished legal professional specializing in dispute resolution, commercial corporate investor and shareholder disputes, intellectual property issues, family and HNI succession plans, and matrimonial matters. She excels in ADR and litigation. She successfully mediated and arbitrated about 250 plus cross-border transactions and commercial and intellectual property cases. Girija ma'am was ranked as the only independent law expert amongst the top 50 law firms and top 15 IP lawyers in India by ALB Thomson Reuters. She is a fellow of Stanford University, earned her master's in law from Cornell University, and is a recipient of the British Council Chevening Scholarship. So I think the introduction says all. We couldn't have a better expert to speak on this topic. Over to you, ma'am.
Thank you very much, Swamin, for this introduction, and thank you for the warm welcome. And I look forward to this session. So today we're going to talk about conflict resolution mechanisms in skills for chartered accountants. So initially, I will start and explain to you what is conflict and how conflict can be managed. And then we move on to the more legal aspects of legal conflicts and disputes, and what are the regular streams that are available for dispute resolution and conflict resolution, which is the litigation side, and then the non-litigation or lesser adversarial forms of dispute resolution, and then mediation. And then we'll talk about what the government has done in terms of reforms in legislations and how what impetus is being given by the government in ADR space. And finally, we will talk a little about what chartered accountants can also look at as career options in conflict resolution. So to start with, I think I would like to explain what is conflict. Now, conflict refers to a situation where there is a clash or a disagreement or a contradiction or an opposition between competitors or any two parties, companies, they could be individuals, it could be family, it could be groups, it could be countries, it could be between ideas, it could be any kind of conflict. And it can basically arise due to differing interests, values, goals, or perspectives. And conflicts may, as I said, it can occur in various situations such as personal relationships between companies, between nations, and they can range from minor disputes to significant confrontations and significant disputes. Conflicts generally arise without a legal agreement or understanding. When there is a conflict that is in respect to an agreement, then it becomes a legal dispute. There are various types of conflicts, as I said. There are interpersonal conflicts, group conflicts, organizational conflicts, international conflicts between countries and political entities. And there are a lot of disputes which get resolved, and there are a lot which stay unresolved. Sometimes you consider actually conflict to be a boon also. Even though humans are resistant to any kind of contradiction or any kind of controversy, still we see that there can be progress is very often grounded in conflict. Although humans tend to have a negative bias about challenges, conflict can be looked as an opportunity. Because if there is a conflict, then you will think, you will retrospect, you will introspect and see what is the reason, why is there conflict, what can be done about the conflict. And so people start thinking and they try to look at options and outcomes of those options as to what can be done to resolve the conflict. So they say that conflict is an opportunity to build relationships, learn from the past, and improve our lives in the future. So we don't have to be so resistant to conflict, even though there's a strong negative bias within human beings to be resistant to conflict. Still, it's considered to be positive in many ways. Now, what exactly is conflict management? Conflict management refers to the way that you handle these disagreements. You could have a disagreement on a particular day and you could resolve it that same day, or it could be an ongoing conflict which goes on for days and days together, or it could be a long drawn conflict which has been going on for years together. We know India Pakistan has a conflict for many years. Now, whether it can get resolved or not is an issue, and whether you want to resolve it or not is also an issue. But in our day to day life and within our families, within our workspaces, within our organizations, if there's a conflict where we are working every day, it can be a huge drain on our human thinking, on our minds, on our mental well being. So it is generally considered better to resolve a conflict. And there are ways and means to first understand conflict and then manage it. So, although many reasons that people disagree, many conflicts generally resolve around personal values where which may be real and perceived. So how do you say, for example, there's an issue with the staff in the office or in your workplace? Now your partner and you're having a conflict on how to deal with them. Who should take what responsibility? That would be a conflict in an interpersonal or a clash of value systems. Somebody might say, no, you must pay higher wages. Somebody might say, no, you may pay lower wages. Then it could be, how do you treat the employees, whether they should be using the same cups of tea as you are using. Sometimes they use different kind of uh, cutlery for them. So all those little things, but they do create a conflict. And then there are conflicts which are based on perceptions. You may think, oh, my friend is gossiping about me, or my business partner is talking behind my back. Now that could be a perception or it could be reality, but it is creating a conflict. Then you have conflicts which are based on different goals. Now you may want to there are two partners. One may want to work only in India. The other one feels, oh no, we should go overseas and we should work abroad and maybe, find better business avenues overseas. But there could be a conflict between the two of you because your goals are different. Your reasons and goals for doing this may be different. And you may not understand the reasons why somebody wants to be in India and somebody wants to be abroad. So, there again, there's a conflict which is caused here. Then there could be conflicts on power dynamics. It could be the management of a company and the employees, they have a conflict in their goals or their cultural differences within the organization. They might want to be treated in a certain manner, the employees, but the management might say, no, these are our policies, these are our rules, but it can lead into a conflict. Similarly, within the family setting, there could be conflicts. The eldest in the family, the eldest sister in the family may have certain ways of looking at how the family should be run, how she should be treated in the family. All of that could create issues and power dynamics. And then, of course, one of the key things in any conflict is the communication style. There are many styles of communication. Sometimes somebody gets very upset, very angry, shouts. screams, puts their point of view very strongly, writes emails which are nasty. The tone of the email is very, very strong. Then there are some people who are stonewalling. They just don't respond. They avoid the situation, which can be very frustrating for the other party. They are passive aggressive. They might do things behind your back and try to stab you. And then, of course, one of the best forms of communication is if you can sit together, you can understand each other and talk calmly and say what you want to say with trust, with a sense of understanding each other, with understanding each other's perspectives and explaining each other what is going on, with the idea to resolve the dispute. That is considered to be one of the best forms of resolving a dispute, but it may not work always. So you have to use different forms of dispute resolution mechanisms at different stages of the conflict to help you resolve a dispute. So there are, supposed to be 5 generally conflict management styles. According to the University of Pittsburgh, professors of management Ken Thomas and Ralph Kilman did a research, and they had an in-depth study, and they said people generally take 1 to 2 approaches in conflict management. And these are either assertiveness or cooperativeness. From these approaches come other styles of conflict management. So basically the 2 things is being assertive or not assertive, and being cooperative or not cooperative. That's the underlying thread of communication and dispute resolution, and how people react to conflict. Now then, the 5 styles that they speak about is, the first one is where accommodating mode of conflict resolution tends to be high in cooperation but low in assertiveness. When you use this style, you resolve the disagreement by sacrificing your own needs and desires for those of the other party. This management style might benefit your work when conflicts are trivial and you need to move on quickly. At home, this style works when your relationship with your roommate, partner, or child is more important than your being right. Although accommodation might be optimal for some conflict, others require a more assertive style. So, very often, this is a good way of resolving a dispute, but we find that when we are mediating disputes, sometimes even if you are very accommodating, the conflict doesn't get resolved because the main issues continue to be there. Your interest may be different from your style of operating. You may be accommodating, but you may desire something else within you. So that has to come out in any conflict resolution situation to help you resolve that situation well. Another form of conflict resolution is avoiding. When avoiding, you try to dodge or bypass a conflict. This style of managing conflict is low in assertiveness and cooperativeness. Avoidance, although, is often found to be unproductive for handling most disputes because it may leave the other party feeling like you don't care. Also, if left unresolved, some conflicts become much more troublesome. So, although in some situations avoidance does help, but generally it is not considered to be a good style of conflict resolution because it can create problems. In some situations where avoidance can work is when you need time to think through a disagreement. Then you may avoid the situation for some time. You want to go and cool down and cool off. Like, as children, our parents would tell us, go take a walk and get a breath of fresh air. And you avoid this conflict, avoid the situation for that time being. But it's a temporary way of avoiding. You have more pressing problems to deal with first, so you may want to avoid the situation because there are more difficult things at hand. And the risk of confronting a problem outweighs the benefits. So you do an analysis in your mind. If I resolve this dispute, I may land up giving up too much. So I prefer not to get into a discussion, not to try to resolve the dispute, because whatever I have
Madam, what happened?
I don't know, the video, the Zoom went off.
No, it's there. You just talked. Right now, talk.
Okay. So, as I was saying, that avoidance may be a technique which is it freezing or it's not, you can't hear me?
Yeah, I'm hearing you.
Because on the chat, somebody is saying that it's freezing.
No, it's there. Right now, we are hearing you. You just go ahead with that.
So, the risk of confronting a problem may outweigh the benefits. So you might want to avoid for some time because it might open a Pandora's box if you try to ruffle too many feathers. So you might think, okay, it's better to sit back and not get into the dispute at all. Wherever I am, I'm happier here. And the resolution is not, there's going to be no resolution for me. It's only giving up my rights or giving up my benefits is much higher than actually confronting the problem. Then the third form is collaborating, which is considered to be one of the best forms of conflict resolution. A collaborating conflict management style demands a high level of cooperation from all parties involved. Individuals in a dispute come together to find a respectful resolution that benefits everyone. Collaborating works best if you have plenty of time and are on the same power level as the other parties involved. If not, you may be better off choosing another style. So, if there is on the one side, there's an individual, and then there's a company on the other side, and they're having a conflict or a dispute, then the small party might feel, the individual might feel, what will I do by collaborating with such a huge giant? And we see this very often in mediations because the power imbalances exist. And it's very difficult for parties to mediate in such situations. They just have to give up their rights sometimes, or they have to give in. Maybe not give up their rights always, but they may need to just give in to what the large company is expecting. But there are ways and means to help that during the mediation process, which I'll be talking about later. This, although is considered to be the best style, but it comes with its own issues because it's well, let's say that everybody takes a haircut of about 2 to 5% in a mediation. On the whole, it's a win-win situation, but somewhere you will take a small little haircut, which everybody should be prepared to. And the expectation should be right and correct. Then is the question of, then is the style of competing. When you use a competitive conflict management style, sometimes called forcing, you put your own needs and desires over those of others. This style is high in assertiveness and low in cooperation. In other words, it's the opposite of accommodating. While you might think this style would never be acceptable, it's sometimes needed when you are in a higher position of power than other parties and need to resolve a dispute quickly. So, yes, this style can work in the benefit of a mediation or a settlement. Even though one party may be much bigger, the smaller party might think and feel, oh, I have nothing to stand in court. How am I going to resolve this in any case? So this may be an opportunity, and let me just finish this matter up. Even though they may not assert their rights completely, they may be willing to do it considering the bigger picture and thinking that it's better to be giving in rather than being over assertive, or so it's it's a better way of dispute resolution. On the other side is the very assertive large company, like maybe maybe Merck or Pfizer or maybe Microsoft, where they have a lot on their side and they're very assertive with their rights, extremely assertive. They come from another country where their rights are protected very strongly. They are in India here. So they may come with a strong bang and say, we are going to take legal action like this and that. They have the power, they have the money power, they have everything. So in this situation, assertiveness might work faster to resolve the dispute because there may be a person who's infringing somebody's rights, a large company's rights. It's maybe a quicker way because, yes, they may not be able to, the smaller party may not be able to assert their rights completely, but they may be in a situation they can't fight. So might as well then resolve the dispute. So this could work sometimes beneficial, sometimes not so beneficial. And then is the compromising style. The compromising demands moderate assertiveness and cooperation from all parties involved. With this type of resolution, everyone gets something they want or need. This style of managing conflict works well when time is limited. Because of time constraints, compromising isn't always as creative as collaborating. And some parties may come away less satisfied than others. So you just quickly compromise and say, okay, I'm done, I'm tired, I have no more energy to do this, and I just want to be done with it. Let me just agree to whatever you say. And you just compromise. And this is not collaborative because in a collaborative style, parties are communicating with each other. They're sitting together and finding a solution. The mediator helps you to find a solution. And you're happy with that solution. Both parties go away feeling very happy with the outcome. It's a win-win situation. Now, what happens? What are the tips that you keep in mind when a conflict arises? We just spoke about how we manage conflict in these different styles. Now, before that, how do you, if a conflict happens, what are the steps you need to take? First and foremost is, which is the most problematic situation, is acknowledging that there is a problem. Most people do not want to acknowledge that there is a problem. They might come into a mediation session and say, no, everything seems to be fine. No, we didn't do anything. It's them who did everything. There is no problem from our side. But there is a problem because obviously you're disputing, you have to understand, even if it means that somebody might have done more wrong than the other, but still there is a problem. So you have to accept that there is a problem. If someone comes and says that there's a dispute that seems trivial, it may seem trivial to them, but the other side, it may not seem so trivial. So you have to be able to, as a mediator, listen to them, understand them, and make them see that there is a problem which might be bigger for the other side, but smaller for them, but it's still a problem. Then is gathering the necessary information, getting all your facts together, getting all the paperwork together, all the documentation. What happened, when happened, what was the agreement saying? After that, when the agreement said these different clauses, what happened? What was the cause of a disagreement? What led to a breach in the agreement? Why did the relationship break off? All the information should be readily gathered and readily available with you before you get into a conflict resolution situation. You cannot resolve a conflict unless you've investigated all sides of the problem. You should take the time to need to understand all the necessary information and also understand all the documentation that exists with you, and at least be aware of the evidence that is with you, so that you are confident when you get into a mediation session. You know what you want. You can also then be able to put down what your interest in this whole situation will be. You will also understand then, if you have the right information and facts with you, as to what your legal stance is and what your stance can be in mediation. Will it be different? And what is it you can achieve through the litigation process? And what is it you can achieve through mediation or by collaborating and finding a solution together? And you can also put down some guidelines for yourself that, okay, when I am going to go and try to resolve my conflict, I'm going to be following a certain process. I'm going to be calm. I'm going to first try to listen and understand what the other person is saying and understand the point of view. And you can also agree to these guidelines and this format with the other party. And then how this discussion will end. And if there is a fight, if there's a disagreement during the sessions or while talking to each other, if it breaks off, you would decide beforehand. If the session gets into a very aggressive mode, then we'll break off. We will stop the session, but we must come back and resume it later, because then you avoid the egos coming in and you have these guidelines set out. Then you're able to come back and find a solution because you've heard each other in anger, you've heard the worst from the other side, and also spoken out a lot. And then when you cool off, you can think, yeah, I think there is a solution here. I think we can find a way out. So sometimes the brickbats are also important during the sessions because that takes out a lot of the emotion and anger, which then helps you to clear the crowds and see the reality of the situation. Generally, during these sessions of mediation or discussion or collaboration sessions, we generally say that you should avoid any emotion coming in. And that's also true when we are trying to handle any litigation or arbitration. We try to keep the emotion side out of it. If at all the emotion comes in, it comes in mainly in conflict resolution through the mediation process. And that's where you get a space to speak to each other in a calm manner, in a safe environment, and in front of a third party where you feel you cannot say anything and everything that you want to say. But you say it in a calmer manner. You say whatever you want to say in a calmer manner. And it also, then you decide in your mind that you will be decisive. You're going to take a decision so that you're going to end it. You're going to see the other person's perspective and then find a solution so that we can sit down together and resolve the dispute. And then take a decision now, not that you leave it for another time, because once you do that, then the momentum is lost. So we generally push the parties, now take a decision. You've heard the other side. You've seen what you've done. You know you're wrong. You're right. They're wrong. They're right. Now just move. Let's come to a decision. Let's not just leave it, because nothing is going to happen by leaving it. It's just going to become into a bigger problem. So it's generally, in this case, when a mediator is using an evaluative skill or just taking an evaluative approach, is when they try to push the parties to come to a decision. They tell them to take an action and find a solution. So that helps the parties to move forward. Now we come to the part which is a legal conflict. I'll just take a minute's break for a second and I'll be back. Thank you.
Hello?
Yes. So now we'll be talking about legal conflict. Legal conflict is one of the forms of conflict in the conflict mechanism and the conflict management space. Legal conflicts are what? They refer to a dispute or a disagreement that arises within the framework of the law involving two or more parties with opposing claims, rights or interests. And generally, there's a legal agreement between the parties which has been breached, which causes a conflict. Or if not, there's not an agreement, then somebody's infringed somebody's rights, their fundamental rights or their rights to use something, or a neighbor has come and parked their car in your space. There are many such places where there can be a legal conflict, which is within the framework of the law. So the law will define what the rules and regulations are, what the law is, and it expects all citizens to follow that law. But in case somebody violates that, then a legal conflict can arise and a legal dispute can happen. And legal conflicts then typically arise in areas such as contractual disputes, which is breach of agreements or differing interpretations of contract terms or non-adherence of any of the terms of agreement will be contractual disputes. Then property disputes which arise, which revolve around ownership. They could be boundaries or the usage disagreements, or they could be also infringing on somebody's rights and lease agreements. You may have rent out your property and somebody is not vacating it. These are all property related disputes. Then there are the civil rights issues, which are conflicts over violation of individual or group rights. So civil rights is are problems like, suppose there is a river next to your house and that has a lot of fuelage in it, and it has a lot of unwanted particles in it, and that's causing health problems to the residents living near the river. It becomes a group right. All the residents there feel that their civil rights are being violated. Or as we see, we hear this often about stray dogs biting people. That can also have civil right repercussions. And then there are the criminal matters, which are allegations of wrongdoing that lead to prosecution and defense. They can be offenses that are committed, or somebody is dragged into a criminal litigation, or an FIR is lodged against them for some violations, which sometimes may be right or may not be completely true. We see a lot of these violations happening under Section 498A, the dowry allegations, and those could be sometimes false also, and they could be genuine also. So those kind of disputes also are existing. And then there are the family law disputes, which are issues related to divorce, child custody, inheritance rights, rights attached to wills, distribution of assets. All these are family law disputes. Then there are the corporate and commercial conflicts, which are disputes involving businesses, mergers and acquisitions, regulatory compliances, and between companies. It could be trademark related, it could be copyright related, intellectual property differences that companies may have because they're competitors with each other. So there can be various disputes here, and also then commercial conflicts also arising from somebody not adhering to the terms of the agreement could lead into a conflict. So they say that conflicts can be, these are the various forms of conflict under legal disputes that arise into legal disputes. However, it also held that conflict can be constructive if managed effectively, because it leads to growth and better understanding, and it can be destructive if left unresolved. So there are two ways to look at conflict. Conflict is a problem, or it's an opportunity to find a solution. When people think about conflict, they usually think negatively. But as I said earlier, that conflict can be having very positive outcomes. Conflict through resolution mechanism can be moved away from a lose-lose situation to a win-win situation. If both parties agree, if all the participants and stakeholders in the dispute agree, then it can be a win-win situation also. And when the parties want to resolve the dispute, then it can be a more win-win situation. Now, when is conflict viewed differently by people or by parties? It is a problem will be solved. They might feel that it can be solved. Some may think it as an opportunity. Some may look at it as a time to learn. Some may look at it to build an alliance or a relationship. And some may think, no, I don't want to. I want to continue to be passive aggressive and I'm not going to sort out the dispute. Basically, if you have meeting of minds to find a solution jointly, then it is the best form of conflict resolution. Now, the next topic that I'm going to deal with is conflict resolution can be resolved through two broad mechanisms. So one is the adversarial form and the other is the amicable form of dispute resolution. What is adversarial? Adversarial is basically when there's intervention or adjudication by a court or a tribunal or through arbitration. And amicable is when parties find a solution for themselves with the help of a third party or even without a third party. We see that over the years, the scope of resolution mechanisms is expanding as conflicts can be resolved through legal mechanisms such as negotiations, ADR, which is alternate dispute resolution forms, which includes mediation, arbitration, conciliation, etc. So we see that earlier it was only, the courts who would handle the disputes. They would call the parties and a judge would write a judgment for you and that would be the outcome of your dispute. But now over time, we see the ADR forms by which parties appoint an independent arbitrator or a mediator to help them resolve the dispute. There are different forms of legal forms of resolving disputes, which is arbitration and mediation, but the outcomes are more in your hand, the party's hands. It's not so much in the hands of the judiciary. It's more the power moves of dispute resolution moves from the court system to the disputing parties. Now, the courts and the tribunals, as traditionally, and they continue to apply laws, rules and regulations, procedural codes, precedents, trial of witnesses and evidence before courts to get a determination and of fair outcomes while the court will give an outcome while upholding justice. So within the legal framework, the court will decide for the parties who's right, who's wrong, and pass a judgment or a decree. Now, this is, as you can see, a very lengthy procedure. It's a very formal way of dispute resolution. It's lengthy because there are procedural laws that you have to follow. You have to do procedural laws have so many aspects to it. You file an application, you file a reply to it. After that, there's a rejoinder to it. Itself takes 5 to 6 months. And then the main petition is filed, which runs into almost 40-50 pages, documents which run into 400 pages. Then there's a reply to that. Then there's evidence that is collected. Then you have to look at the evidence, you have to review the evidence, and the evidence should be as per the guidelines and the law set out in the code or in the Evidence Act. So it's a very long, drawn and tedious process. And at the end of it, the outcome lies with the court, with the judge. But in comparison, arbitration and mediation are different. They are basically based more on the principle of party autonomy. Sometimes the party autonomy can also trump over the judicial intervention. And this has happened. We have many cases which we keep going back and forth in the court where there is the party autonomy must take higher significance in arbitration and mediation, more so in arbitration than what the court suggests or the court orders are saying. It doesn't mean that they should be violated, but that the party autonomy should be taken into consideration. And when I say party autonomy is higher, because the parties agree to get into an agreement. Arbitration is based on the agreement clause that is signed between the parties. That's where arbitration is initiated and it germinates from that. So, for example, when two parties sign agreement, if they don't have an arbitration clause, then nobody is bound to go into arbitration. When a dispute arises, they can go to the court, they can try to get it sorted out, or they can try mediation and try to sort it out. But in case the parties have agreed to an arbitration clause, which is very, very key to the arbitration process, the arbitration clause is where the arbitration germinates, where the dispute is then referred to arbitration, and the courts and the parties are bound to take it to arbitration in case there's an arbitration clause, which is very, very important to the whole arbitration process, because the arbitration clause has to be very comprehensive and very detailed. It should say how the arbitrator will be appointed, how many arbitrators will be appointed, what will the process of appointment, whether it will be a sole arbitrator and both parties will agree to that, and that's the way of appointment, or they say no, there will be three arbitrators. One arbitrator will be decided by each party, and then they will jointly decide, the arbitrators will jointly appoint the presiding arbitrator, a third arbitrator. So the clause must clearly state and specify that. It should clearly state and specify, in case the parties don't agree to an arbitration process, then does the tribunal, the institution under which you're going for arbitration, have the power to appoint the arbitrator. Very often, parties agree that, okay, in case parties don't agree to a particular arbitrator, then the chairman or the head of that arbitration forum, like the Indian Council of Arbitration or the Singapore International Arbitration Center, the chairman will decide who the arbitrator will be for this particular matter. So the parties give the power through this clause to the institution to appoint. And in case the arbitration clause is silent and it says just simply that the parties will go for arbitration, then the court can intervene and help the parties appoint an arbitrator. It's a very key and important process. Then further to that, the arbitration clause will have where the venue will be for the arbitration. That may be given, may not be given, it's not so important. But what is important is which law will be followed by the parties, by the arbitration process, which the parties will follow and the arbitrator will follow to decide the dispute. Is it the Indian Arbitration Act of 1996? And you can also have, there are certain rules that the arbitration process can follow, the arbitrator can follow. These rules could be as per the arbitration center that you're choosing, or it could be any international arbitration rules, which are the IBA rules, which are often known as the IBA rules, are followed by arbitrators to resolve disputes. So when the process goes into arbitration, the arbitrator with the parties can also decide, we are going to follow these rules now. And the parties can consent, and that's put in an order, and the parties consent to that. Then in the clause, parties can agree whether the arbitration outcome will be final and binding on them. Yes, they can put it down there that yes, after this, we are not going to litigate any further. Whatever the arbitrator will decide, that will be final and binding on us. And that is the way that they cut short the lengthy process. Now, under arbitration is considered to be more cost effective and shorter. It is more time bound because, as per the Indian Arbitration Act, an arbitrator has to give his award within 1 year now under Section 29A, and it is extendable on the request of the parties by 6 months more. So it is a time bound process, whereas a court litigation is not time bound. It could go on for years together. We hear this all the time. It can go on for years together. Each party has still not filed their complete evidence, or new evidence has come in, which is not being allowed by the other side. It's a lengthy process, which is not time bound and can become very lengthy. In comparison, an arbitration process is comparatively less formal. It is not dictated by the Civil Procedure Code of India. It is not dictated by the Evidence Act. But generally, arbitrators will follow the rules, but they have the flexibility to sit with the parties and decide this is how we are going to take this process forward. This is what I'm going to ask you to do. You have to file your list of witnesses within this time period. Only 2 lists of witnesses can be done. I'm not going to go beyond that. And your evidence should be limited to this extent. Sometimes arbitrators also have passed awards only on the basis of the documents produced by the parties. They need not hear the other side. They need not hear the arguments at all because these documents speak for themselves. This can be also understood between the parties and the arbitrator. In my arbitrations, when I do that, very often I take a time period by which I ask the parties to file their documents, their pleadings, they file their claim, the counterclaim comes in therein. We complete that whole process and then I meet the parties for arguments. We need not meet them beforehand because it's a waste of time for everybody. You have to find ways to quickly find solutions without compromising on the quality of the work. But it can be less expensive for the parties if there are not too many arbitration meetings because they will be paying the lawyers on every hearing. So there are ways, arbitration, even though it's an adversarial form, it's considered as an adversarial form because it's dictated by an act, by the law, and the parties have to produce some evidence and witnesses. Although it's time bound, it's adversarial because there is a trial, there is evidence that is produced by the parties, and the outcome of the arbitration lies with the arbitrator. The arbitrator is a third person who writes an award for the parties and decides for them what the outcome of the dispute is. Traditionally, this was a very lengthy process, but now with the amendments in the law, this has been cut short. And as I said, now it's become a time-bound process. And so it is more favorable for the litigant, for the client, to find a quick resolution to the disputes. Now, the outcomes and judgments that are passed by the judge, by the adjudicator, the control, as I said, of the litigation lies with either the court or the arbitrator. It is not in the hands of the parties. It relies on the legal system. Once it is in an adjudicatory process, there is little that the parties can do. They have to follow the process and the law as it is codified. And it's a formal process. The court orders or the award or the orders of the arbitrator can be appealed. Court orders can be far more easily appealed and are often appealed and this goes into lengthy arguments and leads into many procedural delays. Arbitration award can be also appealed, but now the amended legislations have very, very limited grounds for appeal. Very, very extremely stringent and very limited grounds, one of which is fraud. And based on that, it's very limited. But in both forms of dispute resolution, which is arbitration and court, we find enforcement can be a very big issue. And very often, the court decree or the arbitration award gets held up in the enforcement process. You must have heard about this, that many awards were challenged in the past on the grounds of public policy. They are against the public policy of India. They continue to be challenged even now under that, but the courts have started reducing the intervention. They encourage the arbitrator itself to decide and handle these questions. But of course, there are limited questions on which it will get challenged. If there has been a fraud, if there have been false documentation that has been produced, and after the award has been passed, the parties get to know all the documents that were produced were false, then they can challenge the award. And so one of the biggest issues that we find is in enforcement. Suppose one of the parties has got a foreign judgment from the UK court or from the US court. Now they have to, and they need to enforce it in India. So there's a whole process, legal process through which they have to go to enforce it in India. And that delays the whole process of finding a solution or an outcome or relief to the parties. Whereas in arbitration also, sometimes over the years, as I said, this is reduced, the challenges have reduced, but the grounds of challenge is far more limited in comparison to litigation. And they don't have a lengthy appeal process. It's only one challenge. It's not an appeal. It's a one challenge that is allowed by the court, by the law, to appeal, to challenge the award or to seek setting aside of the award. So both the situations, the enforcement can sometimes become lengthy and troublesome. And that can have its own problems in extending litigation and having lengthy adversarial processes and delay the conflict resolution or the legal dispute resolution process. And that can be very frustrating. But having said that, still these systems are very, very important to have. The legal system is extremely important to have because it helps you to enhance and to develop the legal system, to make it a more advanced legal system, to build the jurisprudence of the country. The law keeps evolving to have more precedents by which the law evolves further. So by court judgments, since we follow a common law process, through court judgments, the law gets evolved. So litigation is also important, but the parties have to see what is the best process by which they can resolve the conflict or the dispute. Of course, in contractual disputes, in commercial disputes, as I said, if there is a clause of arbitration, then the dispute has to be resolved through the arbitration process. And then all litigation between the parties is generally stopped till the arbitration outcome doesn't come out. Or sometimes they may pursue it depending on the matter. And traditionally, we have a process in court which is known as the interim measures, which is you take interim measures, you want immediate orders. Either you want them immediately or you want ex parte orders. you want ex parte immediate orders. Then we used to approach the court and seek interim measures immediately. Sometimes it is required, somebody's taking maybe a minor child out of the country without proper documentation, and they've been able to take the child out, or they've been able to make the process moving. Then somebody could in the family could file a court, approach the court and say, we need interim measures immediately to stop this process. Their flight should not go. They should be stopped from taking the child out. In property disputes, we often see that one of the parties might say, oh, they're about to sell the property. We need to stop that. Otherwise, once the sale happens, then I cannot recover my dues, or I cannot get my portion of the property. So parties approach the court for interim measures and try to seek interim orders immediately. In earlier years, the Arbitration Act did not have provision for granting interim orders, but now the new laws, the amendments in the law, allow the arbitrator to also pass orders, immediate interim orders. And there is also something known as appointment of an emergency arbitrator, where the emergency arbitrator has to give an award within 14 days, has to pass an order within 14 days of the appointment. So the law has progressed very well in the arbitration area. But it continues to be very expensive, because for a litigant, they have to pay the counsel, they have to pay the arbitrator's fee, they have to pay the tribunal's fee. If it is ad hoc arbitration, then there may not be a tribunal administrative fee, but there would be an administrative fee for the arbitrator, and there may be other administrative expenses, secretarial expenses that need to be borne. In court litigation, there is, besides the legal expenses, there's also the expenses of paying the court fees. So all of that makes these processes extremely expensive and lengthy as well. Now, and also there are some issues that arise in the arbitration process. One of the main issues is that the dispute that happens between the parties should fall within the scope of the agreement. Any dispute which falls outside the scope of agreement will not be accepted under the arbitration process. Now, this determination itself can be very lengthy. It can take very long for the parties to decide, for the arbitrator or the courts to decide on this point itself as to the scope of arbitration. And then also the jurisdiction of arbitration. One party is sitting in London, the other party is sitting in Singapore, and there is a third party sitting in India, and they have a multi-party dispute. Now, how do they decide where the jurisdiction of this dispute is? Which court to approach? Is it going to be the UK court? Is it going to be the Singapore court? Is it going to be the India court or the Delhi court? And within India, which court? This itself can be lengthy issues, and lengthy arguments can happen on these points itself. And that in itself delays the whole process of litigation. It delays the whole process of arbitration as well. But that's a part of the system, because these are important issues that need to be decided from an enforcement perspective. You might get a decree from, say, UK, or you might get an award written in UK, but then it cannot be enforced in India for some reason. Either it's against the public policy of India, or the party has no assets in India. Then the whole process of litigation and arbitration becomes futile. The adversarial process becomes absolutely futile. And there's a loss of money, there's a loss of time, parties are disheartened. This happens in some cases, whereas in some cases, no, it doesn't happen. But we see that there is a lot of delay in the process, and that itself delays the whole process of dispute resolution. And I think it's important for the parties to understand one thing, that whatever way legal mechanism they use, the enforcement is essential to bear in mind. Because after going through the whole process, if you can't enforce it, then it's a futile exercise. So that's what happens in arbitration now. And now we see a trend in the recent few years. Well, it has been in India for very long, but now we see more and more encouragement and impetus coming from the government to opt for mediation as a way of dispute resolution. We've seen that often in cross-border transactions, the parties select either arbitration or mediation as a dispute resolution clause to solve any dispute arising under the agreement. So, but arbitration is bound by the scope of the agreement, but mediation need not be bound by the scope of the agreement. You could mediate anything between the parties. That's why the parties can decide what they want to mediate and when they want to mediate. This can also, mediation is a process which can be included in the dispute resolution clause itself. They agree that the parties can agree that before the arbitration process is initiated, the parties are bound to go for mediation and the outcome should happen within 2 months. And failing that outcome, if the parties are unable to mediate the dispute, then the parties can go for arbitration. So this is what we are seeing now over the years. There are also terms known as med, which are hybrid forms of dispute resolution, where parties move for mediation, then they go into arbitration, then they go back into mediation. Because, as I said, you could get an award under arbitration, but then if you're not able to enforce it, then what do you do? Do you go back to the court again? Do you go back to the arbitrator again? Or through mediation, you can say, okay, let's find a way to enforce this award also. If the arbitrator is smart or the arbitrator has thought it through, they can put in enforcement clauses within the award, but very often we don't see that as the case. So we see that mediation is getting far more attraction and far more references by the parties because it's a quicker way of dispute resolution. It is a cost-effective way of dispute resolution. And it is also more binding on the parties because the parties have themselves agreed to the mediation process first. And if the matter gets settled, they agree with the mediator and they sign on the document. So they have themselves agreed to those terms. And that's how that is sometimes considered to be a far better way of resolving disputes now as comparison to the other adversarial forms of dispute resolution. So mediation is considered to be an amicable form of dispute resolution. More so because it follows less of the strict legal procedural law that you have to bring in evidence, you have to bring in trial, you have to cross-examine the witnesses. You don't have all of that. You have the issues set out in mediation. You understand what the parties want, what their interests are, what their goals are, what their expectations are from the mediation. And with the help of a third party, who's the mediator, the parties can come to finding a solution. So, what exactly is mediation? We define mediation as it's a type of alternate dispute resolution that involves a neutral third party helping and assist the parties to resolve a dispute to reach a settlement. It's a structured process that can be used to resolve disputes in a variety of areas, including commercial, legal, diplomatic, workplace, community, family matters, inheritance matters, any kind of disputes, except for a few disputes, which is it cannot be done in criminal matters. It cannot be done in ownership matters with the government. When the government decides or gives a title deed, you cannot mediate that matter with the government. And there are a few other instances where you cannot mediate certain disputes, but mostly everything can be mediated. Everything that is personal, commercial, intellectual property, mergers and acquisitions, many disputes fall under the space of mediation. I think the mediation space is much wider than any other form of dispute resolution. There is no scope to it. You can, when the parties are sitting across, it happens very often. The parties come in and say, oh, my father has written this will and he's bequeathed this to my brother, my sister, and this, and all that has happened. And then during the mediation process, you find, oh, there is also another dispute pending about maybe the name of the company that is being used by the family. So you can bring in that dispute into this discussion, and that can also be resolved. And very often, many points of discussion and many points of conflict become bargaining chips for parties. So you say, okay, I'll give up the name now because, all right, but you give me this property instead. So it becomes a bargaining way of resolving the dispute and finding a solution. So in effect, mediation is considered to be an amicable form of dispute resolution. Now, I'm going to just quickly run through some of the advantages of dispute resolution, ADR, alternate dispute resolution, which is true for both arbitration and mediation. Firstly, both ADR can be a single procedure in comparison to court litigation. I'll give you an example. In an international IP dispute, which involves various jurisdictions, it could be China, it could be UK courts, it could be France, it could be India, and there are multiple countries which will have multitude of procedures in different jurisdictions. So there is a risk that can happen that there could be inconsistency in the outcomes and results from the court. Now the China court might say, no, this is an infringement, whereas the court in UK might say this is not an infringement. So the dispute becomes even bigger and becomes more complex because different jurisdictions can give different outcomes. Through ADR, the parties can agree to resolve in a single procedure a dispute involving a right that is protected in a number of different countries, thereby avoiding the expense and complexity of multiple jurisdictional litigation. We see this very often in patent disputes because a company might have patents in different countries. And when they're enforcing those rights, it could be multiple issues that arise and multiple jurisdictions. So if you combine them all in one place, which can be only done through the mediation process because other processes do not have a system. It can be done even under arbitration to some extent. But then all the agreements signed in all those jurisdictions should have opted for arbitration in the first place. And the arbitration appointment process may be different in each agreement. That could lead into a problem. But still, an arbitrator could still sometimes find a solution. But in the court system, parties have to go into different jurisdictions and fight their cases. And we see that very often the outcomes could be contradictory and that could lead into more complex issues. Then the second advantage of ADR is, as I said, party autonomy. It's both arbitration and mediation, which are known as the ADR processes, are private in nature. ADR offers parties greater control over the way their dispute is resolved. They have control over their court case. They have more control over the arbitration case in comparison to the court case. The court case has to follow the procedures. Here, the parties have more control over their litigation. The parties can choose the procedural laws. The parties can choose the applicable law. They can choose the place of arbitration. They can choose the language of the proceeding. They can choose the outcome is final and binding or not. So there is more greater party autonomy and there's more control in the hands of the parties in an arbitration process. In a mediation process, the parties are completely in control. The mediator is only assisting them or helping them in their dispute and is helping them communicate, to talk to each other, to find ways and find options as solutions to their dispute, and understanding their dispute and helping them resolve it. The control lies with the parties far more than it lies with in the court process. In fact, the parties are totally in control. It is their outcome. It is their agreement or their settlement that they are in control of. Then in the ADR process, they say the neutrality is higher. ADR can be neutral to the law, to the language and institutional culture of the parties. It can thus eliminate any home court advantage that one of the parties might otherwise enjoy in the context of a court litigation. So if I'm from India and I have to go to Singapore and litigate, I might feel this is not my country. I may be at a disadvantage here, which is far reduced in arbitration and mediation. Because also the other side, who's from Singapore, may be more familiar with the applicable law, with the law that is agreed between the party and the local processes, and can offer significant strategic advantages to the party who's from Singapore. Then further, expertise. The expertise in arbitration and mediation can be higher because the parties can select an arbitrator or mediator who has special expertise in the legal issue, in the technical issues, or the business area relevant for resolving the dispute. So we see that in, say, patent licenses, very often the dispute resolution clause will say there will be one arbitrator who's a mechanical engineer. There will be another arbitrator who understands the law with the legal knowledge. So there could be combinations of arbitrators, and that expertise and knowledge helps in the arbitration process. This cannot happen in the court system. You cannot have technical people in the court system. The courts have, in case they need any technical help, they have to rely on third parties. The judge has to rely on a third party. So in arbitration, you feel more confident. You feel more certain about the outcome because you know now my dispute, which relates to a mechanical device, will be understood by somebody who's going to decide my case. So expertise plays an important role here. Similarly, a mediator who's helping parties resolve a construction dispute. He or she understands the terminology used in the contract, is confident to help the parties see different outcomes, is familiar with the terminology, is familiar with the process, is familiar with time, is the essence of this whole construction contract. So how to manage that, how to quickly move the mediation, how to help the parties find a solution quickly. That is what can be done in the ADR processes. Then confidentiality is one of the biggest jewels in this whole process of ADR, because court cases, court records can be public. Once the order is published, it becomes a public document. Whereas in ADR, proceedings are private. They're absolutely confidential. They cannot be revealed. Similarly, whatever happens, one of the important things we say in the mediation process as a mediator, as an arbitrator, is this is a confidential process. ADR proceedings are private. Accordingly, the parties can agree to keep the proceedings and results confidential. They can sign up and say that this outcome will be kept confidential. This is particularly important as it often is the case in IP disputes. Confidential information or trade secrets are at stake. Very often this information is discussed as to how you came up with a certain formulation or an innovation or a product, but that needs to be kept confidential. So ADR is a good process by which these can be resolved. It also enables the parties to focus on the merits of the dispute without being concerned about its public impact or to their reputation. Because with infringement comes a lot of issues of reputation. Finally, ADR processes have more finality and enforceability processes. There's more finality and enforcement of arbitration awards in comparison to court judgments. Unlike court decisions, which can generally be contested through one or more rounds of litigation, arbitral awards are most normally subject to appeal. Not normally subject to appeal. The enforcement across borders is generally facilitated by the United Nations Convention for the Recognition and Enforcement of Foreign Awards, Arbitral Awards of 1958, which we generally call or is known as the New York Convention, to which many countries are signatories to this convention, and this dictates how foreign awards or cross-border awards get enforced in different countries, in signatory countries. Now, also there is an expedited arbitration, an arbitration procedure that is carried out in a short time, and it's reduced costs considerably. It is time-bound. So in effect, we see that ADR processes are cost-effective, they are time-bound, they have more finality, they have more enforceability in them. And then we come to the aspect of mediation. As I said, mediation is a type of alternate dispute resolution that involves a neutral third party helping and assist the parties to resolve a dispute to reach a settlement. It's a structural process that can be used to resolve disputes in a variety of areas, including commercial, legal, diplomatic, workplace, community, and family matters. Some of the characteristics of mediation are as follows. The mediator is a neutral third party. The mediator only acts as a facilitator. They're skilled. They're skilled to use good communication skills and negotiation techniques to help the parties reach an agreement. They talk to the parties in joint sessions, and they talk with the parties independently or jointly and help them understand the process, to understand the dispute, to understand from them their dispute, their issues, their interest, their goals in the mediation process. We found that mediation helps parties to build a relationship with either your business partners or their family or even competitors. Once they start talking to each other in the presence of a third party in a very safe environment, the parties start realizing the issues. They start realizing, so what? This is such a minor dispute now. I can easily talk to this person. I can easily break the ego and discuss the issue and then take it forward. So the parties can find solutions and they can have the relationship back. I've had cases where we've done a settlement agreement. They've rebuilt a business. they've renegotiated their contract, the terms of the contract, and they've progressed their business far better than what they were before. Because now the mediator has helped them see future issues, pitfalls, any issues that may arise, and help them resolve them in the agreement so that the parties now can easily move forward with their businesses. And as I said, it's a private and confidential process. It's so private and confidential that anything that is discussed in the mediation process cannot be used against any of the parties in a court of law. The parties cannot bring that up in court, and that cannot be used against them. It's a structured process because it is within a timetable, and it differs from the ordinary form of negotiation because there is, at the end of this, there's an outcome. If there's a settlement, there's a mediated settlement agreement, which has legal sanctity. If it doesn't get settled, then of course you're back in the place where you were. Now, mediation basically addresses the underlying interests of the parties. And it not only addresses the factual and legal aspects on the dispute, also the personal, also the business relationship, also the partnership, and social interests that can be contributing to the conflict. It takes into consideration the whole gamut of issues and addresses all of them in mediation. So, for example, there was a case that I was handling. It was a sexual harassment case. Now, the gentleman was a senior officer, and finally, the woman, there were 2 or 3 women actually who alleged it. They apologized because they had combined themselves. They had another issue with the senior officer and then made a kind of a false allegation, or it was a partially false allegation. They apologized. But he said that now I've been defamed. What am I going to do? So we got the parties to write a letter which he could then produce before his next employer, or he could use it anywhere else in his favor. Sometimes it can be also a public apology that can be given. So this can only happen in mediation processes, and it can address far more issues. As I said earlier, it can issue far more issues than any other form of dispute resolution. The scope and expanse of mediation is much wider, and it can be a win-win situation for all the parties when they find an option. Then is the enforcement of mediated settlement is far easier because it's inbuilt into the agreement. The parties will find, sitting with the mediator, how do we enforce these terms now? When will the checks come in? When will the payments come in? How will the payments come in? Will it be in the form of a check? Will it be just an online transfer? All that can be done in a mediated settlement. This cannot happen in a court decree. Not generally. So enforcement is far quicker, far easier in the mediation process. And the challenges are far and few under the mediation process. So at the end of the day, we find that mediation helps the parties to find a quicker dispute resolution process. One of the very big things that we find in mediation is it plays a very important balancing role. Now, I'll just explain this, why I'm saying this, because very often, traditionally, we've seen that parties, when they get into, say, a family dispute, you will just take an elder of the family and bring him in and say, okay, help us solve this dispute. Or their partners who are disputing in a business, they'll bring in some third friend and say, help us resolve this dispute. Although that is a good way to resolving a dispute, what we've seen there is that doesn't help too much because it can be sometimes even disadvantageous because the mediator is not a skilled mediator, firstly. And secondly, the mediator is a friend. Now he or she is put in a position to take sides sometimes, or there exists a bias from their past relationship, is not neutral. So that can lead into issues of using family or, informal ways of mediation. If you take a formally skilled mediator, firstly, they have the skill to handle the situation. Secondly, they are absolutely unbiased and neutral. That makes the environment very, very conducive. It makes it a environment where the parties feel safe to talk to each other, because the mediator has nothing to do with either of them and will not see them after this. So it's easier to talk, it's easier to find a solution. And also in situations where there is too much imbalance of power between the parties, there's no level playing field between the parties, the mediator can help to level that out. One side there's an individual, there's a company. Now, how are you going to find a level playing field here? Then, or there's a small company, there's an MSME, and there's a huge corporate on the other side. The mediator can help to balance the situation. They find ways, they're skilled to handle that situation. They can use different techniques to bring in a safer environment and to bring the parties to communicate and find a solution jointly. And then, of course, mediation through a mediator has no legal sanctity. Now that there's going to be a law, the act is going to be, there's a bill already which will become an act shortly, then it gives more legal sanctity to the whole process. ADR does have its limitations as well. And some of those are that certain objectives can only be attained through the court litigation. In particular, it's not possible to obtain through ADR a decision that would set a public legal precedent. That's not possible through arbitration. The results of an ADR procedure, an award or settlement agreement in principle are binding only on the parties involved. So whereas a court order would be binding over the public generally, or the lower courts, judges have to go according to the precedent. This may not be true in arbitration or in mediation. So, for example, if a party wished to obtain a generally binding decision that the claims of a particular patent were valid and invalid, the only means of obtaining such a public decision would be a court judgment. Rightly so. If you're trying to say that I'm the patent owner, I'm the holder, the patent office is going to decide whether you have actually done an invention or not. So such kind of cases can be only handled by courts or by tribunals, but it cannot be done through arbitration and mediation. In addition, the consensual nature of ADR makes it less appropriate if one of the two parties is non-cooperative. Since both parties must agree to the ADR process, no party can force another to participate. So one of the biggest things in mediation especially is voluntariness. Only if the parties agree can they go into mediation. That's the underlying thread. The parties have to be willing to mediate. They can break off from the mediation anytime they wish to. But it is again the skill of the mediator who helps the parties to come back, helps them to see value, encourages them, motivates them to stay in the mediation and find a solution. So that covers most of the legal aspects about arbitration, mediation, and litigation and dispute resolution mechanisms. I'm going to quickly run through, I think we have only half an hour now. So I'm going to quickly run through some of the laws which have mediation processes within them, which will help you in your careers as chartered accountants. There has been an IBBI expert committee report, which encourages the use of mediation in insolvency and bankruptcy code. So this is encouraged before the insolvency proceedings are started, and it can also be done later during the proceedings, but the law is still not clear on it as yet. There are certain sections of the Companies Act which empowers NCLT and NCLAT, NCLAT, which is the appellate board. NCLT is the NCLT and NCLAT to refer matters to mediation. Then Section 12A of the Commercial Courts Act is a mandatory provision where the parties are supposed to be going for pre-litigation mediation in case they do not need any urgent interim orders, they are bound to go for mediation. Then there is the Consumer Protection Act, which has special cells for mediation, and they have special processes for mediation. The RERA has and other real estate regulations have mediation provisions that parties should try to mediate their dispute. One of the important legislations, which is the MSMED Act, which is a Medium and Small Enterprises Development Act, has a mediation facilitation council. This encourages SMEs to get into businesses because there's a quick process for dispute resolution. In case their money is stuck, there's a mediation facilitation council, and matters are sent to the mediation facilitation council first for mediation, failing which the parties are then sent to arbitration. So these are important provisions of the MSMED Act. Then, as I earlier said, Arbitration Act is time bound. It has 1 year plus 6 months approximately within which an award and an outcome comes out. They also have mediation provisions within it. If the arbitrator feels that the matter can be mediated better, then the matter can be sent for mediation as well. And we see, as I said, hybrid forms of mediation and arbitration now, where both forms are used, and also hybrid forms of litigation and mediation. Matters go into litigation, then they go into mediation, then they go back into court. So they are, in case the matter doesn't get mediated, it goes back into court. So hybrid forms of mediation are also seen. And then, as I said, that there's going to be the Mediation Act, which will have time-bound outcomes. It's time-bound by 120 days with an extension of 60 days. So this is all the initiatives that have been taken for mediation. There are many more. There are also certain judgments that have come out of the court which have important repercussions and encourage mediation. They encourage pre-litigation mediation. In some cases, they almost hold that mediation is mandatory before you go into court. Now, from a chartered accountant's perspective, I have a few points to make. I think that you could consider in this space of ADR and dispute resolution. One of the most important areas where chartered accountants can help is expert witnesses. We take the help of chartered accountants for valuation purposes, for assessment of damages, very often in shareholder disputes, valuation of the company, or in a property dispute, valuation of a property. All these we take the help of expert witnesses. Chartered accountants are very important in this area for us as mediators and arbitrators. And they can be subject matter experts as well. Sometimes we see a chartered accountant with good construction knowledge. That combination helps a lot in deciding construction infrastructure disputes, and it's a highly paying job as well. Then I think chartered accountants can go and make good arbitrators. I think they need minimum of 10 to 15 years of experience, and you can apply to forums and become arbitrators. Also, you can become ad hoc arbitrators and get appointments as arbitrators. And of course, as mediators, where you can undertake training and become mediators, and which can help parties, they have more confidence when they see that somebody has a chartered accountancy background. They have it's very valuable to the commercial dispute. It's very valuable in a corporate dispute. It's valuable in a mergers and acquisitions dispute. The knowledge of chartered accountancy helps everywhere there. And then as conciliators, which is subject matter expert mediators, as I said, and of course, which which is resolution professionals with skills a chartered accountant has huge skills, which is an advantage in the resolution process as resolution professionals. I think with that, I end my topic and discussion. If you have any questions, please feel to ask. What additional technical qualification can help? Sorry, one of the questions is what additional technical qualification can help chartered accountant in this field? So, I'm sorry, I can't hear you. Can you repeat that? I am sorry. Anyways, there's a question here which says, what additional qualification can help chartered accountant in this field? Yes, there are trainings that you can undertake as an arbitrator. There are courses that you can do, there are trainings that you can do, there are international bodies that certify you as arbitrators. Similarly, in the mediation space also, there are bodies which uh, uh, certify you as mediators. The MCA has these trainings, so you can look at that as well. There is the IICA Institute under MCA, I think it's the Indian Institute of Corporate Affairs, which holds trainings. So those are trainings that you can look at for the ADR space. The other question that is here is, yeah, conflict in interpretation of law is one of the major problems. Yes, because there are diverse views. You're absolutely right. There is conflicting views in interpretation of the law. There are conflicting views in interpretation of the agreement terms. So there are, yes, there is a different interpret. Every lawyer has a different interpretation of the law. Distinguish between arbitration agreement and agreement for expert determination. These are absolutely two different things. The arbitration agreement is an agreement between the parties which states that in case there's a dispute between the parties, as per the agreement signed between them, then they will go for arbitration for resolving that dispute. And they will set out the process and procedure in the arbitration clause or the arbitration agreement of resolving that dispute as and when it arises. And an agreement for expert determination is in a way stating that in case there's a dispute, then who would be the expert who would step in? So in case there's as I mentioned, there's a dispute, say, in a mechanical space. Which mechanical engineer will come in? Will it be somebody who's from IIT Delhi? Either you name the expert, or which both parties agree on, or you can leave it to an institution to decide that we would take somebody from this XYZ place to help in the expert determination. And sometimes both parties, each party has their own expert who comes in. Then the experts have to talk to each other and find a way by which they enable and help the arbitrator to resolve the dispute. Can a court order an arbitration agreement to be filed and refer to arbitration a dispute between the parties where there is no suit pending in the court? What condition must be fulfilled to make such an order? Generally, matters go for arbitration when the parties have already agreed to go for arbitration in case there's a dispute. We don't see instances where court sends matters for arbitration without an agreement between the parties, unless the parties come to court in a litigation and then they request the court, both agree that now we want this matter resolved through arbitration, which is a very rare case because the parties are not agreeing on anything. So then the judge can say, okay, I'm going to appoint an arbitrator because both have agreed to go into arbitration. And in mediation, although we see this very often, that the court can send a matter for mediation without having the parties agreed to go for mediation in the past. Even if the agreement is silent on mediation, the matter is pending in court or not even in court, the parties can go for mediation. And even in a pending matter, the judge can send the matter for mediation. what do you do when people take advantage of our calmness and politeness? You handle them with that calmness and politeness, and you continue to do that. So you can be firm. You can be firm and be calm. And you can be polite and be firm, but you can get your point across very strongly still. Will there be change in binding nature of ADR judgment as per the proposed act? Will there be change in binding nature of ADR judgment as per the proposed act? Which act? I'm sorry, could you just state this question again? Which act are you talking?
He may have told about that one is particularly proposed act on that one is pertaining to the
Mediation.
arbitration or arbitration related any proposed topic.
No, so the proposed act is only in mediation.
Yeah, mediation.
Arbitration already has an act.
Yeah, mediation.
Yes, so yes, it will change the binding nature because they will be, well, it already exists. The law already exists actually, that a mediated settlement, a mediated settlement agreement is considered to be almost at par of a court decree. Now, under the proposed Mediation Act, they are only reiterating that and they are taking it out of another act into the Mediation Act. So they are only making the Mediation Act more comprehensive. Even today, a mediated settlement agreement is considered to be at par with the court decree. Will there be change in binding? Yeah, so that is what I said. I hope that answers your question.
Right now, I am requesting C. Amitesh Jain, Secretary, Indore Branch, to render his vote of thanks.
Right.
Ma'am, it was a very wonderful presentation and we got a overall knowledge of arbitration, mediation, dispute resolution, and there is an ample of opportunity for chartered accountant to work in this field. I would like to present a formal vote of thanks. It has been an honor to be part of this wonderful webcast on conflict resolution mechanism skills for chartered accountants organized by Professional Skills Enrichment Committee ICI. On behalf of the Professional Skills Enrichment Committee, we would like to extend our heartfelt gratitude to you as a speaker for enlightening the session, and sincere thanks to the event enablers from Indore branch of ICI of CIRC who enabled the webcast throughout. A wide round of applause and thanks to the organizers, Professional Skills and Enrichment Committee, and other stakeholders who made the webcast a memorable one. Finally, we would like to thank you all present here and helping us to make this webcast a grand success. Thank you very much. Thank you.
I'm grateful for this opportunity. Thank you very much. If there are any questions in the future, feel free to ask me. I'm available on email and mobile, which is available with the center. They can provide that in case anybody requires any answers to any questions.
Thank you. Thank you, ma'am.
I'm grateful for this opportunity. Thank you very much.
With this, we conclude the today's session. Thank you to all.
Thank you. Bye-bye.